Good morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime Live. This is where we cover some of the most interesting live trials and legal stories in the news today. And today we are continuing our coverage of a main live trial, a huge trial that we've talked about all this week. It started yesterday. It's the case of William Knight out of Ohio. Now, this man is on trial for shooting and killing an unarmed man named Keith Johnson after going to his house in an attempt to recover a dirt bike that he believes was stolen from his son-in-law, Curtis Gill. An altercation broke out when apparently Gill demanded the bike back. Shots were fired, and unfortunately, Johnson was killed. Now, for anybody who's been following this case, you know that William Knight is claiming self-defense. What we learned yesterday was that Mr. Johnson, when this altercation broke out, a gunshot was fired apparently from William Knight, a warning shot. Mr. Johnson jumped on his dirt bike, tried to drive away, and according to Mr. Knight, he felt that that was a threat to both him and his family. That is the way that the defense is going, but we have to analyze that a little bit more. Now, I am keeping a very careful eye on the courtroom right now. As soon as it starts, we're going to make sure to show it to you. But to preview this case, we have a short package to explain a little bit more about it. Take a look.
The trial for the Streetsboro, Ohio man accused of shooting and killing an unarmed man in a dispute over a stolen bike is set to begin this week. 64-year-old William Knight is charged with murder and assault stemming from an altercation with 24-year-old victim Keith Johnson. The dispute was over a dirt bike reportedly stolen in 2016 from Knight's son-in-law's garage. The victim had the pilfered bike in his possession and was attempting to sell it on Facebook. Knight and his family arranged a meeting with Johnson at his Akron home to discuss the sale of the bike when everything allegedly went terribly wrong. Knight alleges the victim tried to run over his daughter Michelle with the dirt bike when confronted about the stolen property.
Ma'am, they tried to kill my daughter.
Okay, hold on. Did you just shoot the man?
I had to. He was trying to.
Okay.
He tried to run into my daughter.
Okay, hold on. Okay.
Johnson's family contends the bike was not stolen and that he purchased it from another seller. Is this a case of self-defense or cold-blooded murder? I'm Rachel Stockman for Law and Crime.
All right, let's talk a little bit more about that case. Again, I'm keeping a very careful eye on the courtroom. As soon as we have a feed, we'll make sure to go to it. But I want to bring in my very special guest for this morning, former prosecutor Randy Zelin. Randy, it's good to see you.
Thank you for having me.
That's okay. So we haven't had a chance to talk about this case. From what we've seen yesterday, we saw the beginning of the case. We saw the opening statements. We saw some witnesses being called. What do you make of it so far?
Well, let's pretend today is Monday and I'm a quarterback because I'm going to play Monday morning quarterback. I see a couple of problems with the defense. And let's start out by understanding, as I understand Ohio law to be, it's extraordinarily difficult, as I understand Ohio law, on the issue of self-defense or justification. Typically, it's up to the prosecution to disprove a self-defense defense. But as I understand it, Ohio may be the only state in the country that basically says, no, you defendant, forget your Fifth Amendment privilege, forget your right to remain silent. It's really for you to prove to the jury that you acted in self-defense, that you were justified in doing what you were doing. So start with that difficulty. But think about the defense for a minute. You have flight. That kind of cuts into a self-defense theory. This guy apparently is trying to get away. He's not coming towards the defendant or the defendant's family, which makes it difficult to claim self-defense. But even worse, think about the backdrop of this. This didn't happen on the defendant's turf. It happened on the victim's turf. The defendant went to the victim's turf, and he's already thinking that there's going to be a problem because he believes that he's going there to get back something that was stolen from a member of his family. So in his brain, the prosecution has every right to put in the jury's mind, this guy's going looking for a problem. He's pretending that he is going to buy this bike. He's going there to take this bike back.
Well, what do you make of the argument, and you really heard it from the prosecution, this guy was armed. He was armed, he came there. But then again, let's not forget, he had a right to carry a concealed weapon. He got that permit a short time before this incident took place. So if a man is walking down, whether he's going to the grocery store, whether he's going to what he did here, he has a right to always have a gun on him. Do you take more to that than the prosecution's making, or less, or what do you think about that?
Well, I do think that they're gilding the lily a bit here, because if he didn't have a right to carry it, they would have charged him with the weapons possession. So I think at times a prosecutor just wants to get everything and cover every possible angle. What it does is it dilutes the strength of the prosecution's case. He's got a right to carry the gun. Move on. If I'm a prosecutor, what I am focusing on, as I just said, is one, backdrop. The defendant went to the victim. The defendant went there almost deceptively. He's going there, again, not as a good faith purchaser of this bike. He's going there, he's taking it back. He's not paying for this bike. He believes that this bike is stolen. So those two things weigh very heavily in terms of the prosecution's theory. Self-defense, you got to be kidding me. Then couple that with the fact that, again, as we understand it, the victim is trying to leave a problem as a result of apparently this warning shot, which makes it awfully difficult for the defendant to say, I was defending myself or defending a member of my family. I think what he might have been better served saying is, you know what? I was worried that this guy was going to hurt someone else in taking off. He took off like a lunatic, and I'm concerned that this guy's going to hurt somebody on this bike. So in my mind, I reacted thinking, I got to get this guy off the bike. Again, not the greatest defense, but to me, it's a hell of a lot better than saying, he's taking off, so I'm concerned, what he's going to circle back and come and hit me? I don't like it, and I don't think it works.
Well, it's not an easy issue any which way you slice it, and that's what makes this case really interesting. So, Randy, stand by. We're going to talk more about this case. Again, I'm keeping a very careful eye on the courtroom feed, but I want to talk about another case that we're going to be covering here on Law and Crime. We believe it will start next week on Tuesday. It is a civil case. It's not a criminal case, and it's the case of magician David Copperfield. That's right. A man named Gavin Cox, was an audience member at one of David Copperfield's shows in Las Vegas at the MGM Grand, and he got injured during one of these tricks. And now he is suing David Copperfield and MGM Grand. He suffered some very severe injuries. Let's play a little bit of a preview of that case. It's different than anything we've ever covered, and maybe different from anything you've seen. Take a look.
World-famous illusionist David Copperfield might be forced to break the cardinal rule of magic and reveal the secrets of his illusions in open court. Copperfield is being sued in Las Vegas civil court by 57-year-old Gavin Cox, who claims he was injured during a 2013 Copperfield show in Las Vegas. The British tourist who once cooked for British royalty claims he fell and struck his head on the ground after tripping over construction debris as one of Copperfield's assistants whisked him and other audience members through a dark, secret passageway during the disappearing stunt. Cox claims he suffered brain trauma and is forced to wear an oxygen lung at night because he stops breathing when he's asleep. He's seeking punitive damages from Copperfield and MGM for alleged negligence. The illusionist and hotel strongly deny all claims, stating Cox's injuries were pre-existing and or unrelated medical conditions. This is Aaron Keller for the Law and Crime Network.
As unfortunate it is for this man, Mr. Cox, and the injuries he suffered, it should be an entertaining case, and we might learn some of David Copperfield's tricks, and who doesn't want to know that? So what I see right now is a live feed into the courtroom in Ohio for the William Knight case. But before we talk about that, I just want to preview one other thing for our audience. Next week, on Monday, we will continue our coverage of the Claude Tex MacGyver case out of Atlanta, a prominent local attorney who is charged with the murder of his wife, Diane MacGyver, by shooting her from the backseat of a moving car. He is claiming that it was not self-defense, excuse me, he was claiming that it was an accident, that the gun went off by accident. And now the prosecution really trying to say that he had a financial motive, a financial gain to kill his wife. Well, we'll have to see how that goes when the prosecution continues their case on Monday. They were off all this week. We will cover it live on lawandcrime.com. Okay, everybody, so we do have a live feed right now in the William Knight case. Let's listen in.
In an individual that dies due to a gunshot wound and they succumb to the injuries imparted by the bullet on their body. On the other hand, this is no longer a natural death. That is a violent death. If they are shot by another person, death at the hands of another, that death will be classified as a homicide. However, for example, if they shoot themselves and there is evidence of intent to cause self-harm with that act, that death can be classified as a suicide, for example. Deaths which are neither homicide or suicide are classified as accident. If it is not possible to make a reasonable determination of whether the death was due to suicidal versus homicidal violence, for example, that death can be, the manner of death can be classified as undetermined. So, whereas there...
Okay, so we have Dr. George Sturbens, a medical examiner, the person that did the autopsy on the victim, in this case, Keith Johnson. But let's try to understand a little bit more about what would be happening here in the courtroom. Again, I'm here with former prosecutor Randy Zelin. Why is it important to have the medical examiner on the stand?
That is a great question, because obviously the Captain Obvious issue is if you have a case where someone was shot and killed, you don't need the medical examiner to spend 2 hours talking about the cause of death. We know that, but my sense of it is what's going to be important is that the medical examiner will explain to the jury where the gunshot wound or the bullets went in and where they came out. Right. That's going to be important because, for example, in a justification defense, if you are the prosecution, it is great to be able to have a medical examiner say, hey, the bullet went in through the victim's back. That makes it awfully difficult to say, I was worried that this guy was coming at me and was going to kill me. Conversely, if you're the defense, you want to be able to say to that medical examiner, isn't it true that the bullets went in to the person's chest or the front of their head? So this way, it would be more likely that the victim was coming at the defendant.
Randy, that's a very good point. Let's listen in live to what this medical examiner, and he might be saying exactly what Randy just articulated so well. Let's listen in live.
Office did take fingerprint.
All right, ladies and gentlemen, first let me just start off by saying I know these pictures are extremely graphic, so please do watch with caution. You are looking at the autopsy photos of Keith Johnson in the William Knight case, and that is what it looks like. They are examining the gunshot wound to his head, but what is the legal framework and meaning of all this? Again, I'm here with Randy Zelin. So this is disturbing to look at, sad to look at. The jury's looking at this. What do you think they are making of it?
Well, it seems to me if a bullet starts here and comes out here, that means the bullet is going like that. If the bullet is going like that, that means the defendant would have been over here and the victim is going that way. If he's here and he's going like that, that's called a conviction because there ain't no justification in shooting the guy while he's going away from you.
So let me understand this. For example, if you had a situation where the gunshot wound was to the front center of the head, came out through the back, you would say that was a point-blank shot because he was coming directly at you.
Unless he was going backwards. So
right.
Yeah.
Yeah. Okay.
Absolutely.
That's an interesting that's an interesting part of this. So I know the pictures are very graphic, ladies and gentlemen, but there is an important legal reason for showing these to the jury. So let's listen in a little bit more, and Randy and I will be back to analyze this case in its depth. All right, everybody, we're understanding what happened to the victim in this case, Keith Johnson, really breaking it down in detail, how he died. But let's talk more about the legal aspects of this. Again, I'm here with Randy Zelin. Randy, what's the standard here for self-defense? Is it what would a reasonable person have done in that situation, or is it what was going on in Mr. Knight's mind? Do we take it from that perspective?
It's a reasonable person standard, and what is destroying the defense theory is simply the path of the bullet. Again, if the bullet is entering the back or towards the back of the victim's skull and leaving through the front, it's awfully difficult to argue that I was in fear for my life because the victim was coming at me. Now, we don't know yet, or at least I don't know, where the other family members were standing in relation to the defendant. So, for example, the bad news might be I, as the defendant, don't have a justification defense because the victim's not coming at me. But if it should so happen that the defendant's family was standing off, let's say, to the right, and an argument could be made that the bike is heading towards, the victim is heading towards those other family members, so I take a shot, and that's why it hits there and comes out there. Now I'm back in justification land, because justification is not only me protecting myself, it's me protecting someone else.
I agree. That's really what the defense was really trying to say, that this man, he's a widower. All he has is his family. He was trying to protect his family. Now, the prosecution will say that in the statements that he made after the shooting, first he said he was trying to protect his son-in-law, then his daughter, then his wife, not his wife, his daughter, and just the number of people that increased that he was trying to protect looked a little suspicious. But at the end of the day, if you can try to show that he was trying to protect his family members, because what did you make of the fact that Mr. Knight fired a warning shot, and after that warning shot, Keith Johnson jumped on the dirt bike and tried to drive away?
Again, to me, that's not an indicator of the victim being the aggressor. That, to me, is an indicator of the victim hearing a gunshot or hearing a shot and saying, I'm getting the hell out of here. Now, it's very interesting, because as we're watching the trial, what I'm saying to myself as the evidence is coming out through the prosecution, I'm wondering if the defendant might not have been better off not going for the gold and going for an acquittal based upon justification, because if you have a successful justification defense, that means you never had any criminal intent. You were defending yourself, which means you go home a free man. He might have been better off hedging his bets and saying, listen, I am not guilty of murder. I did not intend to kill this guy. Believe me, I am not that good of a shot. I'm not a sniper that I can hit a guy one shot to the temple and kill him. No, I panicked. I acted out of just pure fear. I didn't know what was happening, or I closed my eyes to the possibility that I could kill this guy. And I fired a shot in his direction, not meaning to kill him. So the bad news is I'm going to be guilty. The good news is I'm going to be guilty of manslaughter and not intentional murder, which means I could end up not going to jail at all, as opposed to going to jail for a long, long time.
That's a very good point. All right, let's listen in. The medical examiner is demonstrating the gunshot wound.
So if you were the shooter and the injuries on approximately this area here, it could have been you were shooting straight this way. It could have been that I was standing sideways looking at you. There's many, many different positions that could have been, that Mr. Johnson could have been in when he was shot.
Yes.
Matter of fact, the number could be infinite, really. Is that fair?
Virtually infinite.
Yeah. Okay. So after you've done the autopsy, you've done the toxicology, you've done everything you've done, you finish up, you memorialize it in your report, and you make your findings in your report. Did you do that in this case?
Yes.
Okay. And ultimately, and I think you have another slide, the next slide, is that correct? Oh, I guess we have the summary. So go ahead and we'll just do a summary. I know you've done a good job of detailing it, but I know you have the slide here.
So in summary.
Let's talk about what you just heard, because again, this is a witness brought out by the state, there's an infinite number of possibilities by which Keith Johnson was shot. Where was his head tilted? What direction was the bullet coming from? This becomes an interesting question and an interesting response for the state's witness. Again, I'm here with former prosecutor Randy Zelin. Randy, in the break, we were just talking about this. What did you make of it?
I want to see if I can get this right. It's like this. Hello, you're the prosecutor. You're supposed to make it simple and clear-cut and say to the jury, there's no reasonable doubt here, because my burden is to prove guilt beyond a reasonable doubt. It is for the defense to talk about, it could have been this, it could have been that, it's possible here, it's possible there. It is for the defense to use the word infinite, or the words infinite possibilities. I don't know why this prosecutor is trying to lose this case, but keeping in mind that the definition of reasonable doubt simply is, if I need more information as a juror to figure out what's going on here, I have a reasonable doubt. What is this guy doing?
Such a good point, Randy. Let's listen in and maybe we can try to understand what he's doing.
your office is able to gauge amount of recent alcohol use. Is that correct, sir?
Yes.
All right. And I believe your report says that the ethanol or alcohol level that you found to be 0.09. Is that correct, sir?
That's correct.
All right. And what is the legal limits in Ohio for alcohol consumption if you were going to operate a vehicle on the highway?
I believe currently it's 0.06.
Well, doctor, if I were to suggest to you it's 0.08.
Oh, 0.08. There was talk of making it 0.06.
Unfortunately, that's true for people
I assumed it was
my profession. If you would please take it, doctor, that it's 0.08. In any event, doc, I don't want to have you misstate something unintentionally. So 0.09, he's over the legal limit. Is that correct, sir?
Yes.
For operating any type of vehicle on a roadway?
Yes.
All right. Doctor, thank you very much.
Doctor, thank you very much. You may step down.
Thank you, Your Honor.
Okay, ladies and gentlemen of the jury, we will take a short morning break at this time. If you would remain in the jury.
Okay, let's try to analyze what we just saw. We saw the end of the direct examination and also the end of the conclusion of the cross-examination there of Dr. George Sturbens, the medical examiner. I'm here with Randy Zelin. Randy, as it was concluding, they were talking a lot about the marijuana that was in Mr. Johnson's system, but why does that matter?
Unless somebody wanted to charge the victim with driving while intoxicated. Marijuana is not exactly a drug which is typically associated with aggressive behavior. In other words, if the defense is trying to establish that the drugs would have made it more likely or more probable that the victim would have been an aggressor and would have been coming at the defendant, I don't know that marijuana is necessarily the right drug of choice. This whole case watching, and one of the really neat things about what we do here is watching trials real time, and you can actually look at a situation and say, wow, that's really brilliant, or maybe you're even more brilliant than anybody on the planet because I don't know what the hell you're doing. I don't know what the prosecution did in terms of ending so weakly by pretty much giving up the fact of infinite possibilities, and the definition of homicide could even be an accident, which is not a crime. And then the defense, instead of jumping on that and simply cross-examining the medical examiner, you didn't know this, you don't know this, you can't establish this, you can't prove this, you can't tell us that, and then just sitting the hell down. I mean, I get a little bit about the whole drug and alcohol use, but again, it's not the kind of drug that would be consistent. It's not like crystal meth or coke where, hey, you're all hopped up, you're all amped up, you're out of your mind. Yeah, you'd come at me. Yeah. I would have simply said, you weren't there, and you can't tell where anybody was standing, and then sit down.
Well, this is his fault for that you're not able to prosecute or defend this case, and someone lost out. Randy, thank you so much for coming in. I know we have to let you go, but it was great to have you on.
Thank you for having me.
All right, everybody, what I want to play for you, because they're in a break right now in this court, I want to play you the testimony of Keith Johnson's uncle from yesterday. Take a look.